Hello everyone, welcome back to day 21 of Polity Daily Drill. Let's begin. First question. Consider the following statements about the anti-defection law in India. Now, anti-defection law is mentioned under Schedule 10 of the Indian Constitution. So, first statement, the speaker can only act on complaints and cannot take suo moto action. What is suo moto? Suo moto means on its own motion. So, the statement says that the speaker or the presiding officer, because under the anti-defection law schedule 10, the presiding officer is the deciding authority on matters of disqualification. So if at any point of time somebody is disqualified, the presiding officer decides whether he or she is disqualified or not. But can he take up those actions on his own, or does he have to wait for complaints? So just to clarify, the speaker can only act on complaints. He cannot take up such actions on his own, right? So you have to complain. Otherwise, the speaker has no power to take suo moto action against any member of the house. So, one is correct. Second one, the whip is a constitutional office mentioned under the 10th schedule. Now, whip is not a constitutional office. Whip, this term has been inspired by the same term being used in UK, and whip does mean that there is a person appointed for each party, primarily called a chief whip, who ensures that the whipping system is in place. Now, what is a whipping system? So, whipping system means another meaning of the word whip. And what is that? Whip means the instruction given by your party to vote in a particular direction. So, on a particular bill, your party boss can say, you are the MP of my party, please vote for yes or no. This instruction given to you is called whip, and the person enforcing that is also called a whip, or usually called the chief whip, and this entire system is called the whipping system. Now, yes, we follow this in our country as well, but it is more a matter of practice. It is not mentioned explicitly anywhere in the Constitution. So 2 is incorrect. Now, which of the statements is or are incorrect? Right answer is B. 2 only is incorrect. Moving on to question number 2. Which of the following states does not have a tribal advisory council for Schedule 5 areas? Now, tribal advisory councils are bodies which are meant for the upliftment of the scheduled tribes in certain states, 10 states to be exact, which have certain districts under scheduled areas, of which we know Andhra Pradesh is one, Rajasthan is one. What about Tamil Nadu? See, Tamil Nadu does not have Schedule 5 areas, of course, but Tamil Nadu does have TAC. In fact, there are 3 states, Tamil Nadu, West Bengal, and Uttarakhand. Now, these 3 states, they do not have what? They do not have Schedule 5 areas, but still have TAC, Tribal Advisory Council. So this means that we have TAC for Andhra Pradesh also, Tamil Nadu also, Rajasthan as well. What we don't have is for the state of Karnataka. So D is the right answer. No TAC for Karnataka. Moving on to question number 3. With reference to the State Legislative Assembly, consider the following statements. Both the governor and speaker can call for a floor test in the State Legislative Assembly. What is floor test? Floor test, or a trust vote, or a confidence motion. It simply means we want to see whether somebody or some party enjoys majority on the floor of the house or not. So this is called a floor test. When somebody wants to prove their majority, wants to form the government, they have to undergo a floor test and win that floor test. Now, of course, the governor can call for a floor test as well as speaker. Both can call for a floor test. Statement 1 is correct. Number 2, composite floor test. So, composite floor test is conducted only when more than one person stakes claim to form the government. This is also correct. Floor test is the system where somebody claims to form the government. However, if multiple groups claim to form the government, then the test is called a composite floor test. 2 is also correct. And number 3, political parties can issue a whip to ensure presence of their members during a floor test. Yes, absolutely correct. In fact, in the Kyoto Holohan judgment of the year 1992, Supreme Court has issued orders regarding the use or the correct use of whip. So Supreme Court has said that the use of whip is fair and fully justified in case of a no confidence motion or a trust vote, that is a floor test. So 3 is also correct. So which of the statements are correct? All of them, 1, 2 and 3. Moving on to question number 4. If the president wants to seek legal opinion on a matter of public importance from the Supreme Court, then, so president wants to seek legal opinion on a matter of public importance from Supreme Court comes under Article 143, the advisory jurisdiction of the Supreme Court. Let's see the options. Supreme Court can assume to itself the power of legislation. This is utter nonsense. This will never be the case. Separation of powers. President has to accept the advice given by the court. Not at all. Whatever advice is tendered by the Supreme Court, the president need not follow the advice. C. Supreme Court may refuse to tender its opinion. This is actually correct. If at any point of time the president seeks legal opinion on a matter of public importance, Supreme Court may or may not give its opinion. However, if the president seeks opinion on a matter which is interpretation of laws or the constitution, then Supreme Court must give its opinion. It cannot say I'm too tired, busy, sorry. It has to. So C is the right answer here. Let's read D as well. President has to first get the approval of the this is in no way making any kind of sense. So C is the right answer. And the last question for today, the fifth question. Consider the following statements regarding Article 24 of the Indian Constitution and child labor laws in India. Employment of children under 14 years is permitted only in non-hazardous roles such as domestic help, hotels and restaurants. 2. Adolescents cannot be employed in non-hazardous industries. And 3. Violating child labor laws in India can result in a monetary fine but not a prison sentence. Now, Article 24 deals with child labor. To prevent child labor, it is a part of the group of rights that we know as the rights against exploitation. So we have a law in the country. That law is called the Child Labor Prohibition and Regulation Act of the year 1986. This is the law which keeps on getting modified at regular intervals to make the provisions more stringent. And since 2006, there has been an amendment in this law wherein the employment of children under 14 years in roles such as domestic help, etc. has been debarred, disallowed. So this is wrong. You cannot employ kids under 14 in such roles as well. In fact, in 2017, this law was modified further to state that kids under 14 will not be employed anywhere. The only two exceptions are a family-run enterprise or the audio-visual entertainment industry. So one is wrong. Now 2 is also wrong. Why? Because in 2017 with the amendment, a new category was created called adolescents 14 to 18 years of age. Now this group cannot be employed in hazardous industries like the three: mines, explosives, and of course inflammables. So these are the three industries in which they cannot be employed. However, they can be employed in other industries. So this would be wrong. Adolescents can be employed in non-hazardous industries. And number 3 again is wrong. Why? Because yes, of course, we do have a monetary fine, a fine from 20 to 50,000 per kid employed in case you're employing a kid. It also has a jail punishment, that is up to 2 years of jail punishment. So third statement is also wrong. So how many statements are correct? D. None of the statements are correct. This brings us to an end of our discussion for today. Let's meet tomorrow. Till then, that is all for me, guys. Jai Hind.